Water ends up where it shouldn't. A homeowner blames the association. Your board assumes you're on the hook, but a Michigan court just ruled that liability for flooding is a lot harder to prove than most people think. Here's the first thing boards get wrong. They assume that if flooding is happening near HOA infrastructure, drains, culverts, common area drainage easements, the association is automatically responsible. That's not how Michigan courts see it. A February 2026 Court of Appeals decision made the distinction very clear. There's a difference between a design problem and a maintenance problem. If water is flowing incorrectly because of how a drainage system was originally built, that's a design issue. Courts have consistently said that associations aren't liable for fixing what was designed a certain way. They're only responsible for maintaining what exists. Most boards don't know where that line is in their own community, and when a flood complaint comes in, they often start making promises or taking actions that actually expand their legal exposure rather than limit it. Now here's where it gets more nuanced and where your governing documents either protect you or leave you exposed. Responsibility for drainage infrastructure depends on who controls it and what your documents say. Does your association own the drainage easement for that affected lot? Does it have a defined maintenance obligation? What does maintain actually mean in that context? The court in this case dismissed the claim against the HOA in part because the homeowner couldn't establish what the association owned, what it was obligated to maintain, or how any failure caused the flooding. 3 separate documentation gaps, any one of which could have changed the outcome. What your declaration, bylaws, and site plans say about drainage elements determines your exposure. Most boards have never read those sections carefully, and most management companies have never helped them do that analysis. The third issue is documentation, and that's the one that can mean the difference between a quick dismissal and years of litigation. Even when an association has no legal liability, getting there often requires proof. Proof that you inspected, proof that you responded, proof that the drainage system was functioning as designed. Without maintenance records, inspection logs, and documentation of how issues were handled, a board is essentially defending itself on its word alone. This same court case involved a homeowner who couldn't prove the system was broken, only that it rained and their property flooded. That's not enough. But associations without their documentation records are in a much harder position to make that same argument in their own defense. Building that kind of institutional documentation is not something most boards think about until they're being sued. At that point, it's too late to build the record. Flooding disputes are emotionally charged, technically complex, and often the result of conditions that predated anyone currently on your board. The legal exposure depends on the layers of detail, your documents, your maintenance history, who controls what, and what kind of record you've built. If your community has drainage concerns, or if you're not sure what your maintenance obligations actually are, we'd be glad to talk through what we're seeing and how to help you get ahead of it. At ManageMax, we know that effective community management is built on transparency and systematic excellence. We provide full-service HOA and condominium management across Southeast Michigan, handling everything from accurate financial reporting to proactive maintenance. Our goal is to reduce the burden on your board while protecting your property values. If you're looking for a partner who values accountability as much as you do, visit us at managemaxproperties.com. Let's build a stronger community together.